A limited partnership. Limited partnerships are pretty common. It was probably the earliest form of partnership ownership other than general partnerships. The distinct difference between them is you have two classes of partners. You have a general partners and you have your limited partners. The general partners generally manage the company. They usually put up money, although they don't have to put up the most. Sometimes they put up a very minority amount of money because they want their time and their expertise. The trade-off is then the limited partners put up the money and the assets and the value. General partners can be generally held liable for the debts of the limited partnership, just like in a general partnership. They can also bind the limited partnership the same way that a general partner can bind a general partnership. And income is also allocated and allotted and passed through the same way that it's done in a general partnership. You can allocate the income whatever way you want to. You can divide it between the general partners. Typically speaking, the limited partners are usually allocated a percentage which is equal to what they contribute in value or in kind towards the limited partnership. So it's not exactly like stock, and there is some flexibility. General partners, you can kind of do whatever you want because the general partners are also compensated for their time in management. So it's not necessarily how much money they just contribute towards their percentage share, but usually the percentages between generals and limiteds and among each of them are allocated within the limited partnership agreement. Also, a limited partnership agreement, most jurisdictions require that you register that limited partnership agreement initially. You don't necessarily have to do it as limited partners come and go, but you have to have a certificate of limited partnership initially to get going, which states who the general partners are, who the limited partnerships are. It appoints a registered agent to accept service on behalf of the limited partnership. If you terminate the limited partnership, you're supposed to file a certificate of dissolution that terminates it. You also have to get your tax numbers, your tax ID numbers, and things like that. So as income comes in, somebody's going to be able to match up income coming in with all the income and all the losses or all the other deductions, however it's being taken by the limited partners and the general partners. So you should be doing that also. But you don't have to file amendments when limited partners come and go because they're very transitional. They do come and go, and sometimes what you see on an original certificate of limited partnership has nothing to do with the transaction that I actually see in front of me. But I do want to see the certificate, and I do want to check with the state and make sure that the limited partnership is still in good standing and hasn't terminated or dissolved or anything like that. It's often recommended, and I say recommended, that you form a separate legal entity to act as the general partner. And the reason is because the general partners can be held liable for all the debts of the limited partnership. So typically what you're going to hear attorneys recommend is you form an LLC or another corporation to act as general partner, so that when the poo hits the fan and all the debts come due and there's not enough money to pay it, the only thing that a general creditor would be able to do would be to pursue the assets of that corporation, which typically has none because you've only formed it for the purpose of management of the limited partnership. Or the same thing in LLC, you've only formed it for purposes of having two members, one of whom is the managing member who acts as the manager and the general partner for the limited partnership. Generally speaking, you can do that. Yes, it's a good practice, but typically I see one or two individuals acting as general partners, hoping they don't get sued. So, generally if you're owning real estate, it's probably not that critical. However, if you're going to say, how can I maximize the protection, then the answer is, well, you should probably do that anyway. And again, of course, insurance, and more insurance. You want to put as many layers between you and the money and the property as you can. And generally speaking, these days, insurance.
Mark, are there any exemptions for taking a property that's held as an individual and putting it in some sort of partnership, or is there always transfer taxes?
Well, sometimes there are exemptions, and again, generically speaking, because even in Maryland, sometimes they differ from Maryland to D.C. to Virginia. But generally speaking, if you own a property in your own name and you form an LLC that has exactly the same amount of members and exactly the same constitution and everything like that, you can transfer them, and there's usually an exemption within the state code. In Maryland, there's an exemption if you own. It's a little quirky. But let's say if you own 5 properties in your name individually and your tax advisor said, man, you're out of your mind, you got to get these into an LLC. If you take and transfer all those properties at one time into one LLC, you don't have to pay an exemption. You don't have to pay recordation or transfer taxes because there's an exemption. But if you take those properties one time, and you actually have to sign an affidavit that says, I own this property, I own these 5 properties, and I'm transferring all of them into one entity. If you try and do them one at a time, then that exemption doesn't apply. So you'll end up paying, you could end up paying tax on all 5 of them. You'd end up paying tax on at least 4 out of 5. But you can do it one time, but you can't do it individually because there's no exemption that provides for it. But I had that same question a few weeks ago, and I actually had to research it. And I said, oh, that's interesting. So you can do it. In Virginia and DC, it's not quite that strict. For the most part, I think if it's constituted the same members, the same shareholders, or if for some reason you own property in an LLC or a corporation or an LP and you change entities, the law has kind of been changed so that as long as it's the same members and the same interest and the same everything, you probably would not have to pay a transfer because it's considered that the title devolves by operation of law. So generally speaking, there's an exemption that covers some of that. But in Maryland, it's a little quirkier. Also in Maryland, I'll get to that later. What else here? Certificate. The other thing that you need to realize is that when you have a limited partnership, the limited partner should not be active in the management of the partnership, because if you start acting like a general partner, then there's a very good chance that at some point when stuff goes south, you might actually find that you're a general partner or be declared as a general partner or found liable as a general partner if you're participating in the management and decision making. So generally speaking, limited partners should be seen and not heard. Limited liability partnership, I don't really recommend this. I don't really see it too much. There's really not a whole lot of advantage that I can see other than, as it says in the outline, there may be some protection from potential liability that arises from wrongful acts of a partner. So although you could be held liable for the debts of the corporation or of the partnership, you really can't be held liable if your partner commits some type of fraudulent act or acts outside the scope of what he's supposed to be doing. You could be if you're a general partner in a limited partnership, but if you're a limited liability partnership, there's at least some protection in most states against being held liable for the fraudulent or otherwise unlawful actions of the other partner. Although again, I don't recommend it, and it's really not that much protection anyway, because generally what you're not worried about is the acts that your partner commits. You're worried about the money that you're going to lose, and this provides no protection against that. It's very rarely used. I very rarely see it, sometimes out in the Midwest, but not around here too much. We really don't recommend it. Corporations. Corporations are historically the most common form of business ownership. It kind of evolved back in the 1500s when they were started to send ships overseas. And of course, they'd send men and money over, and the men and money wouldn't come back. And the bank then would go to the people, the investors, or the people who had borrowed the money and say, we want this money back. And eventually, the government decided that they were losing too much money to keep all these trading companies in business that they wanted to do, the Jamestown Trading Company and all these other ones you read about that started sending ships overseas. So they invented the corporation, and what they said was, if you're a corporation, you could own, it's basically the way it's set up today, you could own shares in the corporation, and the only thing that would be liable for the debt was the corporation, so that if the debt went bad, you would proceed against the corporation. You could have its assets, you could have any money, bank accounts, things like that, but you couldn't hold the shareholders liable for more than the loss of value of their shares. And that worked out fine. And then the bank's lawyers said, well, yeah, that's a great novel new concept. And we got another novel new concept. It's called a personal guarantee. So even though we're not going to hold the corporation liable for the money, in order for the corporation to get the money because you don't have much money, we're going to have all of you sign a personal guarantee as owners of the company. So therefore, now you have the personal guarantee, which still exists today too. The moral of the story is, if you can't afford to borrow money, they're going to require you to personally guarantee it. If you can't afford to borrow money, you're not going to have to personally guarantee it. So, such is life when you borrow money. Stockholders or shareholders own the business. They elect a board of directors who, and if you look, I use the word effects the business, because they decide what you're going to do. How's my time? Because they decide what you're going to do.
Run low.
Running low? They decide what you're going to do, and they basically chart the business. The officers of the corporation put it into practice. Primarily, the good advantages of being a corporation is your liability is limited to the amount of stock that you buy. It's got perpetual existence. In the death of an owner, if you want to transfer ownership, you sign over your stock or you sell it. And you can also, when you buy property, you can lease it in the name of one. Your business entity can lease it from the corporation or vice versa that owns it, so you can get the benefit of ownership and the benefit of leasing the property. The disadvantages of it's a little bit more cumbersome and it's a little bit more expensive, and you also have payroll tax issues if you're the owner. Also, the problem is, we won't get into that now. If you're a foreign corporation, you can file a certificate to do business in the state you're coming into. If you're in Maryland and you want to go to Virginia or vice versa, you can file for a certificate of authority to do business in each jurisdiction, and you can register to do business, and then your corporation goes on and can operate in multi-states. Chapter C and Chapter S corporations, the main primary difference between all these is in a Chapter C corporation, it's a lot more strict, you have a lot more governmental regulations, and it's a double taxation situation. The money is taxed when it comes into the C corporation, and it's also taxed to you as income when you get a return on it. So generally speaking, for these kind of real estate entities, we don't recommend it. Subchapter S corporation is better because money that comes in is passed through. You basically get taxed on what you earn. There is no corporate taxation, but there are a little more strings, a little bit more cumbersome on that too. And finally, the entity of choice is what most people want, what everybody recommends and talks about these days, is the limited liability company. It's kind of a hybrid of everything we've talked about. You set up articles of organization, you register them with the state, you appoint the registered agent, and generally speaking, you have at least two members, one of whom can be the managing member. He has authorization by the articles of organization to sign everything, kind of like the president of the company, who's authorized by either the articles of incorporation or resolution of the corporation. It's easier to deal with. If you're buying property, you just show it to them. Oh yes, John Smith is a managing member, and he can pretty much run it as long as he has proper authority in there. There are some jurisdictions that recognize a single entity LLC, like one member. But if you only got a one-member LLC, then really what you got is a sole proprietorship, and that's the position that some of these states take. So I really don't recommend it. If you're going to do that, then just be a sole proprietorship and skip all the BS and get yourself a lot of insurance, and you'll be a lot better. It is very flexible. You do have to register it. You do have to form it. And for tax purposes, it's treated just like a partnership. You're only taxed on the amount of allocation money that's profited to you. The amount of losses can also be allocated through the operating agreement. So it's very, very flexible. It's easy to maintain. You don't have to have annual meetings. You don't have to have minutes. You don't have to have resolutions or anything like that. You just got to remain in good standing. And if you do dissolve, you are supposed to file articles of dissolution, terminating the partnership through the state. It does also provide you the same, generally speaking, again, in most jurisdictions, it does also provide you the same limited liability that the corporation does. So you're only going to be, so the LLC is only going to be held liable for its debts to the extent it has assets to satisfy them. They, generally speaking, cannot reach the members of the LLC, and that's one of the reasons you want to do that. Most states, including Virginia, D.C., and Maryland, you have pretty good protection through that. Some of the other states out a little bit west, it's not quite so clear, and they don't have all those built-in protections. And of course, the legal disclaimer is this is all general educational advice, so please consult with your attorney and tax professional, and don't pay any attention to what's in this outline, and certainly don't tell them I told you. Anyway, thanks very much.